This is Gareth Aden, and it's April 11th, 2019. I'm here for the Nashville Bar Association Historical Committee, and it's my great pleasure today to be interviewing for an oral history John Branham, who is one of the noted Nashville trial attorneys. John, good morning.
Good morning, Gareth.
Let's begin with the beginning. Could you give us your full name and your date of birth?
John Parker Branham. I was born about 3 weeks before Pearl Harbor, November the 12th, 1941.
And where was your home?
My home was in Lebanon, Tennessee, on East Spring Street.
Well, you're a Wilson County boy.
Yes, ma'am. Yes, sir.
John, tell us a little bit about your mom and dad and your family.
I was the youngest of 7 children, born in my parents' bedroom in my grandmother's house on East Spring Street. And at that time, my father was working for the post office, which he did for about 30 years. My mother was a homemaker, and there were 9 of us that lived in a 3-bedroom house with 1.5 bathrooms and no air conditioning. I'm still not sure how we all got along, but we did. Daddy had the biggest garden in town, and we ate out of that basically year-round.
So you were the youngest of 7?
Yes, and I had one died in infancy, so I had 5 older siblings. They were all very, very handsome, attractive, great students, wonderful people, and I was the bad sheep. I was the typical younger child, spoiled, rotten, and worthless.
Well, now I understand why you defend yourself so well.
I've had to.
Exactly. John, tell us about growing up in Lebanon. I presume you went to elementary school and high school in Lebanon?
I went to Howell Elementary, and I went to Lebanon High School. I had some eye exam done, and the doctor was concerned about whether or not I had some type of problem, and he asked me whether I'd ever been hit in that eye, and I told him not that I remembered. And later, as I was going home, I thought, I went to Howell Elementary and Lebanon High School. I've been hit everywhere. It was a real learning experience. So I probably got hit in that eye several times.
Who was the parent who sort of pushed you on your education?
My mother had a college degree, and my father did not. And both of them pushed very hard. That every one of us went to college. My older brother's an engineer, my middle brother's an oral surgeon, and I wound up as a lawyer. And that was kind of Mother's wish, I think.
With such a large family and your dad working for the post office, did you work during school?
Yes, I actually started, the first job I ever had was Daddy gave me a row of okra that I would cut every morning and take down to Piggly Wiggly and sell for a quarter or 35 cents. And then when I was 13, I started working at a local grocery on Saturdays and after school. And then I worked a couple of summers as a lifeguard at a swimming pool, and then I wound up working at a dry goods store after school and on Saturdays. And then when I was a senior in high school, I started working at the radio station on Sundays, so I worked 7 days a week my senior year. And
how did that happen? I mean, how does a high schooler even think about working at a radio station?
It's a small town, and I just got to know by working downtown in the dry goods store, I got to know the guys from the radio station that would come around, what they call selling time. They were selling advertising on the radio, selling time, Jack Hendrickson, and they subsequently hired me. I had done some public speaking in high school and all, and so I started out doing a teenage radio show on Sunday, and then started filling in, and then eventually went to work there full time.
And did you gave the news and the whole thing?
Oh yeah, I was the local DJ.
The voice of
Yes,
Lebanon.
That's right, WCOR.
During high school, I think you had a signal honor one summer. Tell us about that.
After my sophomore year, I was 15 years old, and I took a Trailways bus, and it was about a 24-hour ride, and went to Washington, D.C., and served for a month as a page in the House of Representatives. And I enjoyed it so much, I didn't want to go home, so I stayed another month and hung around just doing odd jobs. And I was trying to find an opening where I could get a page appointment to stay and go to the page school and stay year-round. That's what I tried to do, but I didn't get taken up on that. So anyway, I had to come home. After a couple of months, I had to come home. But it was an amazing experience. You're right there on the floor of the House of Representatives, and the old saying about if you like sausages and laws, you shouldn't watch either being made. Well, I got to watch laws being made at age 15, and it was quite an eye-opening experience.
How about your schooling? I know you made good grades. What did you enjoy the most?
Literature. I did a lot of reading. When I was young, I had a childhood heart condition, and I spent a lot of time sitting on the wall watching the other kids play and reading books. So I read. I must have worn out several library cards. I think I read about everything in the Lebanon Library back then, and that was my real passion, I guess, was reading, and enjoyed history probably more than anything.
When did you graduate from Lebanon High School?
1959.
Okay. What did you do?
Well, I was working, by that time I was working full-time at the radio station starting that summer. And my brother was in dental school, my sister was in college. There wasn't much room for me to go to college then, so I stayed home and went to Cumberland and took classes there and worked at the station. And so I did that for a little over a year. And then I got a job opportunity to go to WHIN in Gallatin, which was a quote, better, more popular station. Hugh Jarrett, who sang with the Jordanaires, had gone to WLAC, and I took his place in Gallatin on WHIN. And I thought I was really something important at that time. And I had I dropped out of school. I was going to drop out for a semester and then go back, and I wound up staying out for 3 years. I had a job where I had a 5-hour lunch hour. I was on the air from 8 to 10 in the morning and 3 to 6 in the afternoon, and I could play 3 rounds of golf or 27 holes of golf each day during my lunch hours. It was great. I did that for 3 years.
Did this create any problems with mom or dad?
Oh yeah, they were, the whole family was quite upset that I wasn't in college. Yes, I got a lot of grief from everybody.
You know, before we leave it, what was Cumberland College like at that time?
Small, beautiful campus, lots of trees, very pretty place. Some really nice teachers that had been there for a long time, and it was a pleasant experience. It was a small town college at that time. I don't remember when the law school left. The law school at some time left Cumberland and moved to Sanford in Birmingham.
Right.
And that was it kind of took some of at that time, and Cumberland's doing great today, so I don't want to say that, but back in those years, when the law school left, it took some of the allure, I think, of Cumberland away from Lebanon.
So I take it we're at about late 1963. You've been working at the radio station in Gallatin,
Yes.
basically full time. What happened?
I got a draft notice, and the Selective Service wanted me to come visit, and I went down and was examined, and they deferred me for 3 months and told me that they would call me back in 3 months and that I would then be drafted. This was before Vietnam really got hot. They weren't taking as many people. I remember I went down on a busload to be examined, and when we went back, the bus was still half full. I understood from some of my friends that within a year or two, those buses would go back empty after they took a group down to be examined. So I went back to college, and it wasn't so much that there was a lot of emphasis. When I left the radio station to go be examined, they hired somebody to take my place. So I not only
That helped you make up your mind.
helped me make up my mind. I lost my job on the day I went to be examined. So I had to do something. So I went to Murfreesboro and went to Middle Tennessee. And very shortly thereafter, I started work at WMTS radio station in Murfreesboro and did that for a year and a half. My goal was to get enough hours to get into law school, and that was always my goal, to go to law school. So I worked very hard and took all the courses I could take to get those required hours to meet the minimum to get into law school.
What had begun your sort of love affair with law? Why was that an emphasis?
I think the reading and my mother. My mother was she was a Cumberland graduate, and she was quite interested in the law school, and her goal was for me to go to law school. Now, she envisioned that I would probably stay home and go to Cumberland, but Cumberland Law School, as I said, left.
Right.
So that option wasn't there.
Right.
But I think that was a lot of the emphasis, and it just, I don't remember a time, Garrett, honestly, that I wasn't interested in going to law school.
Well, I know that MTSU is, of course, today a huge university, but what was it like when John Branham was on campus?
It was much smaller, and I was there when it became a university, when they actually qualified. As a matter of fact, I emceed the program where they dedicated the new name of the school. The governor was there, and they pulled the drapery off, and where it was Middle Tennessee College, it became Middle Tennessee University, and I was standing there with a microphone interviewing people when that was done. So that was a big event while I was there, that it gained university status. It had a sufficient graduate schools to achieve that. In the few occasions that I've gone back, I don't recognize it. It is just so huge now. But at the time, I'm thinking that there was somewhere around, and this is a guess, maybe 2,000 students, and it's now something up, 8 or 9 or something. I don't even know, or more than that, I
I
guess.
think it's larger than the University of Tennessee.
You're right, I think it is bigger, so much bigger.
Yeah. Well, you mentioned that you were at the microphone for the big event when it became a university. Was that because you were a student leader, or was that because of the radio station?
It's because of the radio station, yeah. They just needed somebody that can talk, hold the microphone, I guess.
Well,
So,
your voice is quite distinct, John, and I understand now you made good use of it.
it kept me from having to work, sitting behind a desk and talking. That may be another reason I thought about going to law school.
Did you graduate from MTSU?
I did, in a strange way. At the time, there were still opportunities to go to law schools without a BS or BA degree, without a graduate degree, if you had sufficient hours and all the required courses. MTSU had, like many schools back then, what was called a senior in absentia program, so that the first year of law school counted as my senior year of undergraduate. So I have a BA degree or BS degree from Middle Tennessee in '66, although I left there in '65, but I had taken all the requirements and was able to let my first year of law school satisfy the remaining electives to graduate.
Well, you made up your mind, or you had already made up your mind you wanted to go to law school. How did you pick a law school? What's the story on that?
I actually applied, I guess, to 3 schools, to Tennessee and to Vanderbilt. And then at the urging of Dr. Parks, Norman Parks, who was head of the political science department at MTSU, I applied at Tulane, and he wanted me to do that because Tulane had a scholarship program. And as I remember, I was accepted to UT, I was accepted to Vanderbilt with the stipulation that I had to finish in those hours and get my undergraduate degree, and I was accepted to Tulane. The difference was Vanderbilt offered no financial aid, and I would have had to stay another semester to graduate. I couldn't have started right away. Tulane, to the contrary, offered a full scholarship. At that time, Tulane and Vanderbilt were about equal in size, and they were both trying to get out-of-state students. If you were out of state and went to a state school, you could apply for one of these regional scholarships, they called it. And I think I told you the funny experience was when I got to New Orleans, one of the first people that I met was a guy from Louisiana who had a scholarship to go to Vanderbilt Law School. And he would have liked to have stayed at Tulane, and I would have liked to have gone to Vanderbilt. We kidded about changing IDs. I think in today's time, we might could have done that. There's so many stolen IDs. Back then, it wasn't too popular, but we didn't do it. But that's why I went to Tulane.
Well, the financial assistance, I'm sure, was important. Did you basically pay for your own education
Oh, yeah.
all the way through?
Yeah, I had multiple jobs while I was in law school, and worked almost all the time, worked every summer. And I had some student loans. I think my student debt when I graduated from law school was $3,000. And I was able to pay that off in just a few years once I started working. So basically, the scholarship was only for tuition and fees. The biggest shock I had was when I had to buy books, and I found out how much books cost in law school. That was a real shock.
How did you manage that?
I didn't buy the books.
You're kidding.
No, I had, at Tulane, and I don't know about other schools, I think you said you weren't aware of this, but at Tulane, they would have what they call skinnies, and the skinnies were outlines. The student who made the best grade in a course would take his notes and make them up into an outline, and then he would sell them or have somebody sell them the next year for $4 or $5 a piece for 10 to 20 page outline of the course that had all the major cases and the holdings and all. And so I would buy a $5 skinny instead of a $25 book and use that. And then I could go to the library when I had to and read the cases if I thought that was necessary.
But wasn't there a day when the professor called on you to stand and deliver?
Yeah, and in constitutional law, the professor, his habit was there were 120 of us in the class, and he would pick one person per day, and he would grill them for 30 minutes of the class on one case, whatever the case of the day, the Supreme Court case of the day was. And so I woke up one Saturday morning, we had a Saturday class in con law, and I woke up one Saturday morning with the premonition that today's my day. I don't know why, but I went to the law school, and I checked with one of my friends to see what the case for the day was, and I went up to the stacks and got the Supreme Court reporter and read the case and made some notes on the case and got into class, and sure enough, within 5 minutes of the start of the class, he called my name and stood up and grilled me on that case. And the funny part about it is that the case book that everybody used was a condensed version of the case. I had read the whole case, including the dissenting and concurring opinions, so I knew more about the case than the teacher did. I got off into subjects that he wasn't even aware of. And, God looks out for fools and drunks, and, and so he took care of me that day.
Sometimes it's better to be lucky than good.
I tell you what, I've always believed that.
How about the people who really affected you in law school, though? Maybe the professors or teachers? Was anyone that really had a profound effect?
The person that probably had the most effect on me was one of my fellow students. It was a guy named Donald Mintz, and Donnie Mintz was from a prominent family in New Orleans that owned several furniture stores, Mintz Furniture. Donnie had gone to school at Columbia. He was a Columbia graduate. And then he had a Fulbright fellowship in South America. I don't remember exactly what country he was in. And then came back to Tulane Law School. We got to be friends very early on. I would go to his home. His family was very kind to me. And we just got to be real close friends. We wound up being national moot court partners. And I think we came in second in the regional, but we qualified to go to the nationals in New York. And we went to New York, the national moot court team. And it was my first time to go to New York City. And of course, Donnie had gone to school there for 4 years at Columbia, and he spent the week showing me around New York City. Don later ran for mayor twice of New Orleans. He was head of the Port Authority. The New Orleans Port Authority, New Orleans at that time was the third biggest port in the United States. And the Port Authority was a huge operation. Don was the leader of the Port Authority. He was a lawyer with one of the top law firms in town. He ran for mayor twice and came very close twice to being elected, but he didn't. He died of a heart attack at a very early age, and I think in his early 50s. And never smoked, didn't drink much, ran all the time, great shape, and had a massive heart attack and died. So when I think of Tulane, I think a lot of Donnie. Had some interesting professors. Obviously, like every law school. You know, a law school, you can have 4 or 5 good teachers and you've got a good law school. It doesn't take a huge faculty to make a law school. And we had Ferdinand Fairfax Stone for tort, and we had Mitchell Franklin for contracts, and Hoffman Fuller for evidence, and Albert Oppenheimer for whatever course he taught. I'm blanking. So we had quite a few characters, and it was an interesting event. Being in New Orleans for 3 years was interesting. I'm glad I did it.
Well, I'm sure you never got to the Latin Quarter or anything like that. I'm sure you never did that.
No, but the French Quarter.
French Quarter,
I
I'm
did
sorry.
go to.
Yeah, the French Quarter.
The amazing thing were how many old friends you had who would call you up around Mardi Gras time. People that you hadn't heard from in years, and all of a sudden, hey, I want to come to New Orleans. Can I sleep on your couch? You know, that type thing. Had a lot of that, but New Orleans was great. I didn't like the climate. I was ready to get out of town. It was the first winter I was there, I froze to death, and it was probably never under, 40 degrees, but it was that damn cold. It was quite different.
Before we leave Tulane, am I correct that you did go to the Nationals in the court?
Right, we did.
And you obviously were already leaning towards trial law, I presume.
Yes, I don't recall a time that I didn't think that lawyers were supposed to go to the courthouse. That's what I thought lawyers did.
Yep.
If I knew today that you could make a living sitting in your office doing less stressful things, I might have made a different choice.
I doubt it, John. Knowing you, I doubt it.
I don't know.
So, you would have graduated, I'm guessing, in about the spring of 1968 from
68,
Tulane.
yes.
So, what did young John Branham decide to do?
Well, I didn't know. I had a good job offer in Houston. I had been active in the law school. I was president of the student body. I was active somewhat on campus and activities. I had some good contacts. I had won the Best Oralist Award in the regional moot court competition, and so I got some interest from some firms. My grades weren't outstanding, but I had some other activities that I'd done. I had worked, I was a member of the Teamsters Union and loaded trucks on a freight dock for about 6 months, and had a pretty varied background. I interviewed with a law firm in Houston. One of the top trial lawyers there had an interest in Tulane people. I've forgotten what his connection was, but he had some connection to Tulane. And they made me a very attractive job offer, and I went out to Houston and spent a few days and decided I didn't want to live in Houston. And so at the last minute, I decided to come back to Nashville, And so I had to kind of hustle to find a job.
Yeah.
And at that time, as you remember, Gareth, Nashville, for some reason, different from Atlanta and Birmingham and Louisville and Memphis, Nashville had very small law firms. The biggest law firm in Nashville, when I came to town, I think had 15 lawyers. And so there weren't that many job openings, especially for somebody that went to school out of state and didn't have any family or whatever connections. through a series of events that are too long to explain, I wound up fortunately getting a job with the Metro Legal Department as a assistant Metro attorney. And I started there in the summer after I got out of law school.
Who was the Metro attorney at that time?
Neil Brown,
Okay.
Mayor Briley, the original Mayor Briley was in office, and Neil Brown was the director of law. And I started actually as a clerk because I hadn't taken the bar exam and didn't have my license. And so I actually was in a clerk position until I got my license. And it was the greatest thing in the world. Within 2 weeks of getting my license, I tried my first jury case. And, you know, with help, with somebody telling me what to do. But I was in the courtroom trying cases. Young lawyers today just don't have the advantage that you and I had of getting to go to court.
Exactly.
To actually try lawsuits. And that was the greatest thing for me. Don Binkley was a circuit judge at the time, and I tried my first 2 jury cases in front of him, and after both cases, when everything was over and the case was closed, he called me up and took me to lunch and told me all the things I'd done wrong. And that was the best mentoring I think a young lawyer could have, is to have a circuit judge come down and take you to lunch and tell you what you've done wrong.
Believe it or not, he did the same with me.
Well,
I'm
glad to
serious,
hear it.
and he was a great guy.
He was a great guy, and I'm very glad to hear that.
Who else was working at the Metro Legal Department at that time?
Bob Kendrick was the assistant director of law. Bob just recently died. He spent a lot of time there, and he spent a lot of time with the Attorney General's office, and I think he may have had a federal position for a while. And Milt Sitton was one of my contemporaries there.
He became director after Neil Brown.
Later.
Right.
The other person who was there that you would know quite well and is a member of the American College of Trial Lawyers is Tom Carlton. So I tried the first few cases I was with Tom. So that was another great influence. Chuck Griffin was there, and Chuck, after some months when I was there, Neil Brown retired, and Chuck Griffin became the director of law. And Chuck was a young lawyer, very bright, very energetic, wanted to get things done, and working under him was quite an experience. He started the push for the Governmental Tort Liability Act. Every year, the legislature would introduce a bill that said the doctrine of sovereign immunity is abolished in Tennessee. And the trial lawyers and everybody would push it, and the insurance companies and the governments would fight it. And there was a fear that someday that law was going to pass. So Chuck and some other legal directors, I think from Chattanooga and Knoxville and maybe from Memphis, and the Tennessee Municipal League decided that the best thing to do was to get their own bill together and introduce it in the legislature and have some limitations on what could happen. The fear wasn't for Nashville or Chattanooga or Knoxville. The real fear was for Ashland City or Laverne, who could get hit with a $3 million judgment and put the city out of business. And so the whole idea was how to protect these smaller municipalities and counties from what were then considered to be huge judgments. Chuck gave me the chore of writing the first draft of the Tennessee, what eventually became the Tennessee Governmental Tort Liability, TLA, whatever. I can't even remember the initials, but the Governmental Tort Liability Act. And GTLA, I guess, is it. And that's what it eventually became.
Did you have a chance to work with my old mentor, Dean Wade, on that?
Yes. As a matter of fact, we set up a committee to work on it, and Dean Wade was the chairman of the committee. And I'll never forget, at the first meeting that we had, I had labeled it the Governmental Tort Immunity Act. And Dean Wade said to me and to the committee, if you want to get this thing passed, you better change the word immunity to liability, which we did. And I think that helped a little bit of sugar helps the medicine go down, and I think that made it sound a lot better.
That's a great story. How long were you at Metro Legal?
A year and a half, and it was a very eventful time. I appeared in federal court several times on constitutional issues. I defended Metro on the motorcycle helmet law, which was a new thing that Metro had just passed. That was the first case that I argued before the Tennessee Supreme Court, and won that. And Rudinoff versus Metro. This was a very wealthy man who liked to ride motorcycles and didn't like to wear a helmet. And so he took it on and took it all the way to the Supreme Court, and the Supreme Court affirmed the Metro ordinance requiring motorcycle helmets.
How about that? So we're, I guess, at about 1971. What did you do after Metro Legal?
1970.
70,
Yeah,
okay.
January 1970, I started to work with Glascow, Adams and Taylor, which was a firm of about 5 or 6 lawyers that did a lot, not totally, but a lot of insurance defense work. And I worked with Mac Glascow, Alf Adams, and Dick Taylor. And most of the trial work that I did, I'd say the majority of the trial work I did was insurance defense work and done with Mac Glascow. During that time, you mentioned Milt Sitton. Milt Sitton had become the director of the legal department, and Mayor Fulton decided to fire him. And Milt decided he didn't want to be fired and pointed out that in the charter, it says that the director shall be appointed for a term the same length of the term as the mayor. So Milton took the position that he could not be fired until his term ran out. And he got some of his friends, Tom Carlton, Tom Higgins, Mickey Miller, and myself to represent him. And the 4 of us represented him in the case of Sitton versus Fulton. And the eventual outcome was that we won it in the appellate court, and they held that he could not be immediately terminated. Milton went back and worked one day and retired. And that was, I think, the wind up of the case. But it was a very interesting case.
It was. Well, it was a case that had some profile in Nashville.
It did.
What was it like working for Mac Glasgow? How was that?
Wonderful to work with, hell to work for. If you were working with Mac and trying cases together, it was great. When he'd walk in on Friday afternoon and drop a file on your desk and tell you that he wanted a brief ready to be filed by Monday morning, it was not a lot of fun. But Mac was a pretty good but he taught me some good habits. I mean, Mac was all for preparation. That was his thing. He did a lot of hard preparation. And I always felt like that the hour you spend in the courtroom, you need to have several hours getting ready for that hour in the courtroom. And I think I learned a lot of that from Mac. And Mac was very good in trying jury cases. And that's what I did. Alf Adams had a much more variety of a practice, and I really enjoyed working with him. Alf would tell you every so often that the reason the state of Tennessee gave you a license to practice law was because you raised your hand and took an oath and swore that you would use it to help people. And if you weren't helping people, you weren't doing what you swore to do. So Alf was a great example. Dick Taylor was a lot of fun. I just really enjoyed him. I had a great time, great friend.
He was a favorite at the bar.
He was a prince of a guy, just couldn't be better. And so working with him was great. We had some good cases, but we had a lot of fun.
How long did you stay with Glasgow, Adams, and Taylor?
4.5 years.
Okay. What happened?
The whole sequence was Steve North got elected judge.
I remember that.
In the summer of '74.
Fifth Circuit?
Yeah, in Fifth Circuit, and he beat Judge Phelps in a contested election, which was unusual. And Steve was going on the bench, and Doug Fisher called me and asked me if I would like to take his place at Howell and Fisher. And I did. I moved 2 floors down, in the Court Square building. I moved from the 6th floor to the 4th floor and went in practice with Doug and Moat Howell, and at that time Johnny Harwell was there with us.
Right.
And there were 4 of us, and that started my career with Howell and Fisher.
Well, this week, I know Doug Fisher passed away, and I know that had a profound effect on not only many lawyers in Nashville, but you. Tell us what Doug was like to work with.
Doug, I worked with Doug for 19 years, and we never tried a case together. We worked on few things together. We appeared probably maybe at a couple of motion hearings or whatever together, the 2 of us. But Doug did his own thing. He was very focused. I've never known anybody with such a laser focus as he had. When he was working on something, he was totally into it, totally committed to it. We had a little cloakroom and where we would hang our coats in the morning. And I went in to get my blue blazer to go to lunch one day, and it wasn't hanging in there. And I found a blue blazer hanging there that was much smaller than mine. And I went and knocked on Fisher's door, because he kept his door closed most of the time. And I went in, and he was sitting behind his desk in my blue blazer. And I said, "Doug, have you got my blazer on?" And he looked kind of funny, and he said, "I wondered why the sleeves were so long." But that's the type of thing that Fisher wouldn't notice. It's just that wouldn't bother him. One of Doug's favorite lines, I would rush in all upset about something. "Did you hear about where Gareth Aden tried this big lawsuit and so and such and such? Did you hear all this?" And Fisher's response was, "Nobody's paying me to worry about that." And that was kind of Doug's attitude. But, and the one thing I want to emphasize, Doug set a standard that even though I didn't work with him, I worked around him. And he set a standard for preparation, for integrity, for honor, for total commitment to your client within the bounds of the rules and the law. And Doug Fisher probably turned away more business than most lawyers get because he didn't want to take a case because he thought there might be some conflict or something wrong with it. And he would just say, "No, I'm sorry." He would periodically call his insurance companies and tell them, "Don't send me any more business. I've got all I want. I just don't want any more to work on." I had a real hard time convincing him to hire some young associates in the firm because he said, "I don't want to be a teacher. I don't want to be responsible for some young kid." And after a while, he caught on, and he told me one time that I taught him how to make money because he had several associates helping him do his work. So it was quite an experience. I love Doug, and we'll miss him a great deal. We had lake houses next door to each other up at the lake, up at Old Hickory Lake. And my most pleasant memories of Doug are some of those hours we spent on the screen porch late at night when our wives had gone to bed and the kids had gone to bed, and he had a scotch and I had a bourbon. And Fisher was an amazing raconteur when you got into those circumstances. A heck of a life. 26 years old, and he was the governor's counsel, making all kinds of decisions, doing all kinds of things.
He was a very good friend of Val Sanford's.
Yes, and loved Val Sanford.
And they did. They really
Yes.
admired each other, and I had the honor of sitting there sometimes when they were talking about the old days.
Yes.
It was fun.
Yes, he said, and I've heard him say it many times, that Val Sanford was one of the best kept secrets at the Nashville bar, that most people just didn't realize what an amazing lawyer he was.
There's something I've got to ask about because it's always been a little bit of a mystery at the bar. How did that firm work financially?
It was a
I've
mystery.
got to ask.
It was a mystery to us. What do you mean at the bar? We had this Chinese algebra bookkeeping system where every month we would get a report individually about what we brought in and what our expenses were and what was allocated to us. And for example, if I had 2 associates working for me, if there were 12 people in the firm and I had 2 associates, then I would pay For 3 people, I'd pay a fourth of the printing cost or a fourth of the whatever cost, and it was all broken down in this long report that we got every month. And you know, we would go for months and months and months and not get any money. We wouldn't get a penny because it would all go to expenses. And then sometime the wheel would turn. Doug Fisher's line was always, "It's in the pipeline." He'd always say, "Don't worry about it, money's in the pipeline, it's in the pipeline." One time, Philip North's wife told Philip to tell Doug to get a roto-rooter to that pipeline. She was tired of not having any income. But it was a strange situation. And typical Fisher, I mean, Fisher wouldn't spend $300 to paint the lobby of our building because he was afraid the insurance companies would think we were getting too lavish. And then he'd turn around and give $1,000 away to somebody just to be nice, you know. So that was Fisher. But it was a strange system.
Tell us about, 19 years is a long time.
It was a long time.
How was your practice developing? I know that, you gained a profile in defense work primarily during that period, but I think you also had some CNA case? Or?
Yeah, I had the typical spread of insurance defense work in all types. Our 3 biggest clients were Travelers, Aetna, and then St. Paul. And at some point, I picked up CNA and started doing a lot of work for them. But as the years went by, and as I got to know more lawyers and tried more cases, I began to get referrals on cases other than insurance defense work. And that became more and more my practice. And those cases were bigger cases and generally paid better fees than insurance defense work. And so I tried to develop those and started being lucky enough to get most of those. Most of my practice, other than insurance defense work, were referrals from other lawyers, which I really appreciated.
Did you take part in the Waverly Railroad litigation, the huge explosion that took place?
Yes. Phil North had 2 clients who, the first one came through his church, the Madison Church of Christ, that a person who attended the church who knew Phil and his family. And from that person, we then got a referral to another injured individual who turned out to have probably the most serious case of all of those. And the Waverly explosion occurred in 1978. It was what's called a BLEVE, and I think that's a boiling, liquefied, expanding vapor explosion, if I've got all the letters right, but it's called a BLEVE. And there were several people killed and major injuries, primarily burn injuries, which were horrible to contemplate and for the people to go through. And it was my first experience, and most lawyers' first experience, with the complex tort litigation manual that the federal courts had. There was a committee, the plaintiffs' committee of 5 lawyers. There was a defendants' committee of 5 lawyers. Doug Fisher, John Connors, Dave Alexander, I'm not sure who else were on the plaintiffs' committee. And Ward DeWitt was the liaison with the defense committee. Tom Higgins and I think maybe Tyree Harris and some others were on the defense committee for the defendants. And as I said, there were 30 some odd cases that were all consolidated together.
Right.
And I did some work on that for the committee, for the plaintiffs committee. And my primary job was to put together a videotape, a 30-minute videotape about the explosion and about the cases. I got all the videotape I could get from all the local TV stations. I got all the pictures I could get from the Tennessean and the Banner. And I wrote a script, and I sat there with two videotape recorders, one to play the tape and one for the master, and a microphone, and I made up this 30-minute videotape that we showed to the judge when we did the settlement conference. Judge Norton did a settlement conference of all those cases and got them all, I think all but one maybe settled. it was an interesting experience. My first experience with major tort litigation, and there were lawyers coming out of the woodwork, coming from all over the country, trying to get in on these cases, and it was kind of a spectacle. It wasn't a lot of fun parts of it.
Well, you began to, I guess, in the 80s and the early 90s to sort of get a profile of not just being an insurance defense lawyer, but you were also into plaintiff work in trial practice.
Yes.
Did that lead finally to a change?
Oh, yeah, it did, and it was one that I thought about for a long time. I used to go up to my lake house, and I would get on my lawnmower and ride around cutting a pretty good yard. Doug Fisher would sit on his front porch and dictate interrogatories and requests to admit while I was out riding my lawnmower. But he kidded me all the time about all the money I was losing riding the lawnmower. But I would think about the fact that I was spending about 80% of my time on insurance defense work, and I was making about half my income off non-insurance cases, including some plaintiff's cases.
What did you do?
Well, I did a seminar out at Vanderbilt with a young lawyer named John Day, and we did this seminar for Vanderbilt students on some subject, and we walked across the street to the Wild Boar for a glass of wine, and about 2 weeks later we started a law firm. And I left with some great reluctance my partnership at Howell and Fisher and Branham at the time, and John and I started Branham and Day, and I stayed there 14 years, and we focused on doing plaintiff's work. We did no insurance defense work.
Where were your offices located, John, for Branham and Day?
We started out the first year, we were in the LNC Tower, and then we moved into this building, into one Nashville place, and we spent the next, I guess, 6 to 8 years here in this building, and then we moved to Brentwood, to Maryland Way, I think maybe in 2000 or 2001, and we were there for 5 years, and then I left at the end of '06. I had always said I was going to retire at age 65, and I turned 65 and I proceeded to retire, and that lasted about 6 or 8 months, and my dog wondered why I didn't go to work, and I was fortunate enough to have some offers to come back, and so in the fall of I guess '07, I started with McAllester and Norton off counsel, and that's where I am today, 12 years later, so I'm still working on retiring.
Let's talk about those years at Branham and Day. Well, what was it like to practice with John Day, and then tell us about some of the cases that you had.
Well, John was very, again, he was a very focused person. I practiced law with 2 guys that I would say are really laser focused, John and Doug Fisher. John is extremely bright, extremely energetic. He would start early in the morning and go till late in the day. He did our original arrangement when we started is that I would focus on the hourly work and try to bring in enough business to pay the rent and pay the secretaries and keep the law firm running. And John was, at that time, was focusing on medical mal cases and bigger cases, more complicated cases. And, he might go 8 or 9 months without bringing in a fee, but when he brought in a fee, it was a substantial fee. And so that was the way our model started over the years. And I was fortunate enough to have some of those good cases also. And so those were good years business-wise.
Did those years encompass the Richland golf course case?
The Richland case actually started, I think, when I was still with Howell and Fisher.
Tell us about that.
Well, Richland Country Club was a beautiful piece of property right off of West End with a really classic old-style golf course that was designed by one of the premier golf course designers in the country. I've forgotten all the names, but it was a highly lauded course, and the members loved it. A group of developers decided that they would like to have that land. It was where the projected 440 interchange was going to be located, and they wanted the land for development for housing. So they came up with a plan to buy some land out of Granny White Pike and to build a new country club, which they would then trade to Richland for the old country club in town. And that would be, I think, kind of an equal trade, and they would get that prime real estate right off of West End at 440 to develop for fancy homes and condos, etc. And Richland would get a new country club, a new building, new facilities, new tennis courts, etc. And they would, the sweetener to the deal was they hired Jack Nicklaus as a golf architect to design what was called a Jack Nicklaus signature golf course. And I say that because we later found out in discovery there wasn't any such thing. It's just he put Jack Nicklaus, he wrote his name on it. That was how it became a signature golf course. But in any event, Jack Nicklaus came to town and he designed this beautiful golf course with lots of up and down. He used a contractor that he did a lot of work with. And the contractor built the course primarily during the summer months in the midst of a massive drought when it was very dry. And it was a beautiful golf course, but you couldn't leave it out in the rain because in the fall, when it started raining, 3 of the holes that had been built back in this one section just basically crumbled and fell apart. It just came tumbling down. The land contained colluvial soil, which is an unstable soil, and once the rain started, colluvium will stay in place forever until you disturb it, and then if you work it and disturb it and don't properly compact it and protect it, it won't stay in place. So that's what happened. We filed a lawsuit. We tried to settle it. The Nicklaus people were very unwilling to settle the case. I was chosen by Richland to represent them, I think because I had quit playing golf and I was no longer a golfer, and so I wasn't going to be wanting to come out and play golf all the time. And we sued Nicklaus and the developer and the contractor. Nicklaus turned around and third-partied in everybody, every sub who had worked on the job. So we started out with like 3 defendants. We wound up with 9 or 10 defendants. And it was a tough case. We took a lot of discovery, had a lot of experts, and finally wound up with a mediation. And the guy who's the great mediator, who's done the 9/11 mediation, I never can remember his name. But anyway, he was going to be the mediator, and so we had this 2-day mediation over at one of the hotels. And I've got to tell this story because he didn't show up. He sent a couple of young guys. He got tied up in some mediation in Washington or New York, and he sent a couple of his young associates down, and they kept us waiting. We sat there for 2 days, and at the end of 2 days, they came in and offered us, our damages were like $2 million, 2.1. They came in and offered us like 1.1, take it or leave it. So we got up and walked out. And when we got back to my office, I was with the manager from Richland. They were calling me, wanting to get me back on the phone, of course, to talk. And we had a new phone system. I had trouble getting the phone to work. And I could hear them, but they couldn't hear me. The phone line was muted. And so this guy was talking to his associates, and they were telling him what happened. And he said that we went in and we offered so-and-so. And he said, what did Branham do? And they said, he got up and walked out. And he said, well, that's so. And I'm sitting there listening. And about that time, I got on the phone. And I've got to give him credit. I said, hey, I heard that. And he said, John, I'm glad you did. I want you to know how concerned I am or something. So anyway, they wound up, we settled it for about the $2 million that we had claimed. It it was a good settlement. It was an interesting settlement because they wound up paying off our note that we had borrowed to do it.
Now, let's talk about some of the other really high-profile cases. You had mentioned to me a yacht club fight.
That was probably the first big non-insurance case that I got in. There was a funeral home in Nashville, out in West Nashville, that had a houseboat. You may wonder why a funeral home had a houseboat. Well, it had some grappling hooks on it, and it would occasionally be used to search for drowning victims in the river. Some people might think it was just for pleasure, but no, it did have a purpose. And so they had sent a couple employees out to clean the houseboat up in the spring, and they did. They spent the day cleaning the boat up, and they took it over to the gas dock, and they filled it up with gas, and when they started the boat exploded, or the motor exploded and caught the boat on fire. Everybody ran, cut the lines, the wind took the boat, blew it over into one of the big piers, and caught a whole line of boats on fire. I think there were 30 some odd boats that were either burned up or damaged. And so you had all these people, all these boat owners, all upset about their boats burning up. So a lawyer who was a very good plaintiff's lawyer, and one of my dear friends, I don't want to mention his name, filed the first lawsuit. And he filed it in federal court, and he alleged that it was navigable waterway, and that the laws of admiralty applied. He wanted to do that because under admiralty in those days, you got comparative fault as opposed to contributory negligence as a defense. So he filed it in federal court and alleged admiralty. All these other lawyers joined in, and they all said, that's great, we'll all get in the suit. Well, I went to law school at Tulane. One of the big courses in Tulane is admiralty. I didn't take it, but I had a lot of friends that did. And I knew there was such a thing as a limitation of liability. So I got a lawyer in town, a retired lawyer from New Orleans named Bart Williams, to help me, who had done admiralty work. And we filed a petition for limitation of liability. This was started hundreds of years ago when seafaring first started. And if you wanted to ship a shipment of goods from London to Boston in the New World, or you wanted to ship something from Boston back to London, you could buy into this and you could limit your liability like a corporation by having an interest in the ship. And the limitation of liability was that your liability was limited to the value of the hull at the conclusion of the voyage. So if somebody got killed, if somebody got robbed, if pirates took all the goods, if the ship sunk, your liability was limited to the value of the hull at the conclusion of the voyage. I knew that just from sitting around the break room and hearing my buddies talk about limitation of liability. So we filed that. And we filed a bond for $500 for the value of the hull that had burned up. And we went out, the amazing part about it, all the lawyers on the other side were mad as could be. They said, you can't do that, you can't. Well, we did do it, and you can do it. But I hired Darrell Townsend to help me. He was a law student at Vanderbilt. I hired him to help me because Darrell had spent a year on the Metro Police Department. He was a policeman for 1 year before he went to law school, and he knew all the cops. And so I hired a guy named Mike Wiesner here in town who had a boat shop as an expert. And we went out early one Sunday morning. Mike got a work barge with a crane on it, and we got on an old houseboat and we went out to Commodore. Darrell got a couple of his buddies from the police department who were trained divers, and we went out there with this work barge with a crane on daybreak, 5 o'clock in the morning on Sunday morning. I remember because I had a hangover. And the divers went down and found this burned up houseboat, hooked the cables to it, we lifted it with a crane, and we took it back to Mike Wiesner's boat shop. And we had an expert from Vanderbilt, a metallurgist, who examined the gas tank and found there was a rusted hole in the gas tank that nobody could see because it was on the bottom of the tank. And it was perfect. We had 2 employees of a corporation. The limitation of liability only applies if the owner is not actively involved in the negligence. Well, we had a corporation, Tennessee corporation, that had 2 employees working on the boat. And we paid $500, and that's That was the limit of the liability as far as my client was concerned.
That's an incredible story.
Well, one of the great things is that I got Daryl Townsend out of it, who then became my associate and then became my partner and has remained my friend, so that was the great part.
John, there is another case that I think you had as a part of sort of your profile as a lawyer, where you represented Charlie Daniels. Could you tell us a little bit about that?
I had a long relationship with Joe Sullivan, who he worked at a radio station in Manchester when I was working at a radio station in Galton. We met when we were teenagers. Joe went on to form Sound 70 Productions that did all of the big promotions in town. And at some point he decided, he met Charlie Daniels and he liked Charlie, and Charlie was starting to go out on his own. Charlie was a renowned studio musician, fantastic musician, or sessions musician. And he recorded with everybody that came to town wanting Charlie to play guitar or fiddle or banjo or whatever. Yeah. And so anyway, he wanted to do his own thing and form his own band. And so Joe decided that he was going to manage it. And Charlie had some lean years and then started having some good years. And he recorded a song called The Devil Went Down to Georgia. He signed a huge contract with Columbia Records while we were representing him. And I think at the time it was the biggest single country artist contract in Nashville. And so Charlie did real well. And when you do real well, people come out. And there were a couple people, I think, that made some claims against Charlie. The big one was John D. Loudermilk, who was with Acuff Rose Publishing Company, a well-known songwriter in town. And he had a song called Bad News that he claimed that Charlie had copied when Charlie did his song, Long-Haired Country Boy. And Long-Haired Country Boy was a hit for Charlie Daniels. Bad News had been years before. So anyway, Acuff Rose decided they were going to pursue the case on behalf of their writer, Mr. Loudermilk. So they filed suit against Charlie and Columbia Records and everybody connected with Charlie. And Richard Frank and Aubrey Harwell represented Acuff Rose and John D. Loudermilk. And I represented Charlie along with Mary Schaffner. And most of those cases are settled. That was the tradition. You settle.
Right. You work it out.
CBS was amazed that Columbia Records were amazed that Charlie wouldn't settle, but he just refused to settle. So we had a trial, and we had, both sides had experts on musicology. Excuse me, it's an interesting case. I worked out with Charlie. It's the only time in my life I've ever typed out a script of every question that I was going to ask him. And we met on Sunday night out at his house. The trial started, I think, on Monday morning. We met out at his house and went through all these different songs, and he was going to explain how he wrote the song and everything. And he couldn't remember the words, he couldn't remember the music, it was tough. And he said, well, I'll work on it. So we started the trial, and we went through the trial, and Charlie was going to take the stand on Thursday. So on Wednesday afternoon, after we got out of court, we went back to my office in the Court Square building, and Charlie sat there on the couch in my office, and I went through the script with him, and I'd ask him, what about this song, what about that song? And he couldn't remember the words, he couldn't remember the music, whatever. We got into court the next day, and we had it all staged. There was a guitar hidden under the defense table, and at the right moment, when I was asking him questions, he said, well, if I had a guitar, I could show you. And Mary Schaffner hands me the guitar, and we hand it up, and the judge allows him to take the guitar and to start playing the guitar. The courtroom was packed. It was just wall to wall.
Whose courtroom was
Judge Nixon, John Nixon. And it was just absolutely packed with people. I was afraid they were going to start applauding. I was really concerned that they didn't do it. But what I want to tell you, that the amazing thing to me is that when Charlie, sitting up there on that witness stand, got that guitar in his hand, that stage persona kicked in. And Gareth, it was perfect. He knew every word to every old song. He knew every guitar riff to show what he'd done, everything. it was just that stage presence, that courtroom full of people that he performed. And it was beautiful, and he did a great job. And poor Aubrey had a hard time trying to cross-examine him. It didn't go well.
Well, I'm sure.
And so, anyway, we won it, and it was a lot of fun and quite a success. It got a lot of national publicity, and I went back to my office thinking that the phone would ring and that I would get a lot of business. I got one phone call from a guy out in Los Angeles that wanted me to hire him as an expert witness. And that was the only call I ever got out of it.
Okay, well, you knew that I had to ask about this because this is a case where everybody in town heard about sort of a showdown between you and the famous Jim Neal of Watergate fame. Tell us about the Exxon case and what that was about.
I represented two men who had gotten together up north and had decided they had both spent some time in Nashville and they liked Nashville. And both of them had good-sized families, and they moved their families to Nashville, and they started a little company here in Nashville out on Sitco Drive that did real well. And it was in the plastics business. I won't bore you with all the details, but it was in the plastics business. Exxon, that was a huge manufacturer of plastic goods to supply downstream to these companies, they decided they wanted to do a multi-level. They wanted to get in all levels of the business, so they started buying smaller companies. They bought a 20% interest in my guy's company with an option to buy it all after 5 years. After 5 years, my guys didn't like Exxon at all and didn't want to sell, but Exxon forced them to sell. Exxon literally threatened them that they were going to sue them. They actually had a complaint drawn up and showed them the complaint and said, if you don't sell to us, we're going to sue you and blah, blah, blah. So they sold. Under duress, they sold. About a year later, Exxon, who knows how to run huge businesses, doesn't know how to run small businesses. Exxon had run it into the ground, had run off all the customers, and it was losing money. And Exxon decided that they had been defrauded, and they filed this big thundering lawsuit claiming that they had been defrauded in the purchase of this business. It was a plastics business. It relied on its lab, and it turned out that Exxon had never looked at what was going on in the lab. So we went to trial, and the Hale and Harwell were representing Exxon as they had done all over the world. And they got conflicted out because some of their people were going to have to testify. So they brought this very good trial lawyer in from Austin, Texas, to try the case, along with his associate. And we went to trial in front of a jury and Judge Stronger. And I thought that we were going to lose. I thought there was no way that we could win this case. I was really, really concerned about it. And they had all these lawyers on the other side working for Exxon. And the day before the trial, we started on Tuesday morning, the Monday before the trial, they sent me a 3-page letter telling me what they would let me say on my opening statement. And it kind of upset me, and I decided I wasn't going to roll over and let them win as easily as I thought they would. So it became pretty tough. We tried it for 3 weeks, and in the process, Jim Neal was one of the witnesses, and my clients kept saying they wanted me to really go after Jim Neal, and I said no. He's a baron of the bar. He's extremely well respected. I'm going to treat him very nicely. I'm going to be very kid loved with Mr. Neal. And it didn't turn out that way. We got into a kind of a shouting match and went toe to toe for a couple of hours there in the courtroom. And in any event, after 3 weeks, we not only won the defense of the case, but we got $4 million on our counterclaim, and it was a really, really good outcome. It was also probably the hardest case I've ever tried. I think I was just totally, completely exhausted.
Well, trial lawyers know what those cases are like.
Okay.
You need a vacation for a month after it's over.
Really did.
Gosh, John, I think you also did work on the famous Stieglitz collection at Fisk University.
I did. That, when I came to Bowman McAllester, that case was going on. And I got involved in it for two reasons. The first reason was I'm a great fan of modern art. I've got a house full of modern art. And I was very attracted to just the interest in the case. I'd been reading about the case and been very interested in it. And so I wanted to get involved. And then as it worked out, they needed somebody to kind of take over the litigation end of it. So I wound up trying the cases and the appeals. And it was an interesting experience. The plan was to sell an interest in the Stieglitz collection, which had been donated to Fisk back in the 1940s by Georgia O'Keeffe, who was the widow of Albert Stieglitz. And Stieglitz was an art dealer and collector and a famous photographer all in one in New York. And he had left a huge collection of art when he died. Miss O'Keeffe, as his widow and executrix, was obligated to do something with that, and she wound up donating a large portion of it to various institutions. She gave some of it to the Art Institute in Chicago. She gave some of it to MoMA, the Museum of Modern Art in New York, as I recall, about 4 different institutions. But through a contact that she had at that time with Fisk University, she gave 101 pieces of the art to Fisk, including one of her paintings that became really iconic, and the Georgia O'Keeffe painting of the Radiator Building, which became so valuable and so big. Fisk had reached a point back in those years, back in the 1940s, Fisk was doing pretty well, doing quite well. Over the years, attrition and changes and all, Fisk had financial problems, and they came up with a plan to try to sell a couple of the pieces of art. That was vigorously opposed by lots of people that didn't want them to sell any part of it. Alice Walton of the Walton family was building a big museum called the Crystal Bridges Museum of Modern Art in Arkansas, and she made an offer to purchase an interest in the Stieglitz collection for $30 million. That was very, very appealing and very attractive. And so Fisk wanted to take that. Because it was a charitable gift, they had to go into court and get permission from a qualified court to do that. And so they wound up in front of Chancellor Lyle, who I have the greatest admiration and affection for, and I think she's an outstanding chancellor. But she didn't like what Fisk was trying to do. And so she had ruled against them on several occasions. The first thing that happened was an outfit called the Georgia O'Keeffe Foundation out in Santa Fe, New Mexico, came in with a basically unlimited budget and wanted to fight the court approval. And they put on a huge battle. Sherrard and Rowe, outstanding lawyers, wonderful lawyers, did a marvelous job in fighting us, and prevailed until we went to the Court of Appeals and they were knocked out on the standing issue that we've been raising all along. At that point, the Attorney General of Tennessee, who had previously approved the arrangement on 2 different occasions, decided he didn't like it either, and so he began to oppose it. So then we fought the Attorney General's office, the biggest law firm in the state of Tennessee, for the next couple of years, and wound up finally winning in the appellate court, and Fisk went ahead and did the deal with Alice Walton. It was a wonderful arrangement for Fisk. It was a wonderful arrangement for the art. It was going to provide the care that it needed. There's a theory in the art world that I can't understand, and that is that a museum or an entity that has art donated should never be allowed to sell that art ever unless it's to buy new art. That's the only exception. You can sell a painting if you turn around and buy another painting with the money, but you can't sell it to operate it. It was their position, and this was kind of the motto of the Museum Association of the country, is that Fisk ought to just go out of business and close down and let the art be donated to somebody else instead of selling an interest in it. Doesn't make any sense to me, but that was their position, and that's what we had to fight, and we eventually prevailed.
Yeah, that's a case that I guess took you, what, 5 or 6 years?
The whole case, I think, lasted about 5 years. I was involved for about 4.
Well, I know that Fisk appreciated your work because I think they're doing better now, and
Yes,
and
and
that's
it's a
good.
wonderful institution in many ways.
John, let me ask you about judges for a minute. You've tried cases. You're blessed to have tried probably more cases than most trial lawyers do. Who are some of your favorite judges that you've appeared before?
On a good day, probably Tom Wiseman is one of the best judges ever to try a jury case in front of. Tom had some, I think, cluster headache problems. Occasionally he would not be feeling good, and you would get that feeling early on. But all in all, he was a great trial judge to go in front of. There were some of the judges out in the various counties that I liked. Young Tommy Boyers, who was in Gallatin, was just a prince of a guy and a very good judge. His father was a judge for a long time, and I got along quite well with the older judge. I had a lake house, as I said, on Old Hickory, and I took all the cases in Gallatin I could get, and I would try to schedule my depositions on Friday afternoon or Monday morning where I could spend the weekend at the lake. And I tried lots of cases up there and really liked them. Judge Hale up in Cookeville was a good judge to try cases in front of. Tom Hale, I don't know if you remember
Yes,
him or
I
not,
do.
but he was a very pleasant judge. Of course, we had some outstanding chancellors too, and I don't like to pick favorites. As I said, Ellen Lyle is outstanding and has done a great job. Bob Brandt, when he was on the bench, with the exception of the Richland case, was an outstanding. Bob didn't like golf courses and country clubs. He thought they were ruining the environment, so he wasn't very nice to in the Richland case. But other than that, he was a great guy and an excellent judge.
Who are some of the best trial attorneys you've locked horns with?
Well, you know, I've always said that you don't really get to know a lawyer until you have a case against them. You can work with them, but you don't really get to judge their preparation, their integrity, their competence until you've been on the other side of a case with them. And I always, when I lost cases, and I lost my share, certainly, I'd always brag on the other lawyer because I didn't want some stumble bum to beat me. I'd always talk about, boy, that guy was a great lawyer, you know. And I don't know, it's hard to pick out people. I had a great relationship for years with Alan High, and Alan filed lots of lawsuits, and I got a lot of insurance defense business against Alan High, and I thought he was just a prince of a guy, and I kidded him when he became a chancellor. I told him that I lost a big segment of my practice because he was no longer filing all those lawsuits. I had a long and very good relationship with Jack Butler, and Jack and I were friends. We did seminars together, and we had cases against each other, and I liked Jack a lot. C.J. Gideon is a super trial lawyer, and I used to do seminars with C.J. and Tom Brothers together.
Yeah, I had a case with CJ, and you're right, he's extremely capable.
Very good.
And a good strategist. Can we loop back for just a moment? Tell us a little bit about your family, your children, where you've lived, and things like that.
I have 4 children, and 2 of them are my stepchildren, but they've been my children since they were 5 or 6 years old, so I consider them as my children. I was married for 25 years and have been divorced for about 25 years, and I have 2 children from that marriage. So I have a total of 4, and I have 8 grandchildren, and several of them are coming over tomorrow night. So I'm looking forward to that. I always look forward to seeing them. I'm very fortunate. I've got 8 good kids and 8 great grandkids.
Well, there was a rumor for a few years that you were a farmer. What's going on with that?
Gareth, I had this obsession that I was going to buy about 50 or 100 acres down in the country, and I was going to retire and move down and be a hobby farmer. And I looked all around Davidson County, and the prices were so high, I must have gone to Williamson County 20 times, or out around Leapers Fork and all, to look at property. And I saw this ad in the paper for some land down in Bedford County, and I went down and looked at it, and I thought, boy, this is as pretty as Williamson County. And I had reverse sticker shock. The price was so low from what I'd been looking at. Instead of getting 50 or 100 acres, I wound up with about 600 acres. And I've had it for about 18 years now, and for the first 5 or 6 of those years, I couldn't wait to get up in the morning, to wake up, to run down there and get on the tractor or get on the mower or whatever and just really enjoy it. We cleared a lot of land. I had some helpers, and we did a lot of work down there, and it's a beautiful place. But after you bush hog the same field 20 or 30 times, it's not as much fun as it used to be. So I'm in the process of trying to sell my farm. I moved to College Grove. I moved out of Nashville to College Grove a couple of years ago. I've got about 7 acres down there, and that's all I want. Would you like to buy 600 acres down in
Thank
Bell
you.
Buckle?
My John Deere won't do 600 acres. Let's talk for a minute and sort of wind up on your observations about law practice in general. You know, you practiced now, gosh, a number of years, and you've been practiced all over Middle Tennessee, probably some out of state. What are the changes, the goods and the bads you see in practice?
The bad is that people don't try lawsuits. Now, some people would say that's good. Maybe you shouldn't have to go to court to settle your differences. I feel just the opposite. I think that our court system, our jury system, is the best in the world, and it's worked well for hundreds of years. And I think it ought to be utilized more than it is. The growth of mediations, for shorthand, I say that when we stopped being trial lawyers and became litigators, the whole world changed. Litigation is different from what we used to do. Many times it's a war of attrition. You try to wear the other side out with the interrogatories and requests to produce and all of that, and just beat it to death. The motion practice is more extensive than it used to be. The old style was to get a file and get to work on it and get it ready and go try it. Mediations, I do some mediations, not many. I'm not holding myself out as a mediator, but I do some. And I'm surprised how many people come to mediations just as a checklist point. They're not really there to settle the case. They're there because somebody told them you need to mediate, or that's part of their procedure is that you go to mediation. Lawyers have settled cases between themselves for hundreds of years. You don't need to hire a third party and pay them to carry your messages back and forth to try to settle the case. You ought to sit down and try to settle it yourself. But so I'm not a huge fan of mediation. I think there's some circumstances where you've got some recalcitrant clients or some hard-headed people that just need a third party to come in to kind of help, to mediate, to actually do a mediation. I think that's great. But just considering that every case has got to go through a step, and one of the steps is mediation, I don't think is all that worthwhile. So I'm not a fan of that. I've never been a fan of arbitration. I just don't think arbitration is a real fair way to settle. I don't want to do anything where I don't have a right of appeal. I want to be able to take it up if I need to. So those are my main observations. The one thing that I have consciously done because of the effect of mediations, it used to, when I would take a deposition of an adverse party, if that party was lying, I would encourage them. I would say, oh, tell me more. Did that really happen? Yeah. Oh, wow. Because I knew that I was going to pull that document out that they had signed 2 years before that they had forgotten and beat them over the head with it in front of the jury. So I would save all my good stuff for the jury. when we got into the situation where people were mediating all these cases, I started to be, and I think it's become, more confrontational on discovery. Today, if I took a deposition of an adverse party that was lying, I would reach in my briefcase and pull that document out and show it to him, and show on the record that he was lying. I wouldn't want to get to a mediation and have all the good stuff in my briefcase. I'd go ahead and bring it out. So I think that's made, at least from my standpoint, it's made discovery more confrontational than it used to be.
How do you rate Nashville as a place to practice law?
It's always been a wonderful place to practice law. The stories that I hear from other cities are scary. My experiences that I've had with lawyers from Chicago, from New York, especially from California. The California practice of law appears to be like a 180 from the way we do it here. So I have not enjoyed that part.
You know, a lot of people don't know it, but I think that you were one of the founding members of the Harriet Phillips Inns of Court.
I was, and that was a wonderful experience. Bill Cope did a marvelous job. He got some of us together in 1990, and we were the founding masters, and I served as a member of the board of the Inns of Court for several years. And I had been, as you had been, you and I had both been very active in the Barristers Club in years past. And I was president of the Barristers Club back in the 70s and really enjoyed it. And the Inns of Court brought a lot of that back, bringing the judges, the young lawyers, the older lawyers all together in one room for a bit of conviviality and then some seriousness. I thought was a wonderful step. So
I think it makes all the difference to actually know somebody.
Yeah. And Judge Cope just deserves a huge amount of credit for doing all that.
What does your future hold? You're still practicing at McAllester.
I tell people I'm off counsel, and when they say, what does that mean? I say, well, I don't know what it means in general, but in my case, it means I don't work very hard and they don't pay me much money. And I'm very happy with that right now. That's where I want to be. And, as long as I've got enough sense to digest my food, I'm going to try to show up. Woody Allen says that 80% of success is just showing up. So I try to show up 2 or 3 days a week. And, I don't have any plans to change that immediately.
Well, I'm hearing you, believe me. John, this has been tremendous fun. Is there anything we've left out?
The one thing that I'm proudest of in my practice is that in 1988, after 20 years, I was inducted into the American College of Trial Lawyers. And that, first of all, getting that at that age was a great pleasure to me and very important to me. And that's the organization that I've been the proudest of to belong to. And it's an organization that I think does a great job nationally. It's involved in lots of programs and does lots of things. I've been, or used to be, and not now, but I used to be very active in the local bar, in the Nashville Bar Association. I was a director. I served on multiple committees. I was the chairman of several different committees for years. And I always thought that if you had to focus your energy on anything, you ought to focus it on your local bar association. And I'm not saying that because I'm sitting here in the Nashville Bar offices. I'm saying that because I really believed it. I think that's the best opportunity to get to know other lawyers, to get to know the judges, to get to know the systems, to get to know how to be a lawyer, and it's through your local bar and your local bar program. So I encourage any lawyer, young or old, to be active in the local bar.
Well, you've done that today, and you've given us a wonderful history and look back over many years of fine practice. Thank you so much.
Thank you, Gareth. I'm honored to be here with you.